A very good morning to all my lovely students. I know how eagerly you have been waiting for today's session, and even we are excited over here to take up the last topic of the Sale of Goods Act, that is unpaid seller. So I hope students, you have revised the first three chapters. A very good morning, Mr. Yuvraj. Yes, definitely. The class is again going to go well because you all have revised what you have done in the previous class, and we're going to wind up with the sale of goods today as well. Mr. Hitesh, good morning. Pavan, Sonam, Vishnu Deo Thakur, Aditya Kumar, Yash, Priyanka, Dev, Sakshi, Mr. Naved, Mayank, Anjali, Sanya, Tejvan, Lakshmi. We have Lakshmi also today. Satish, Surya, Dheeraj, Varun, S. Sudhakar, all of you. Good morning, children. I hope you all are doing great and you have revised. I hope you have done the descriptive questions also. Children, it is very important that as soon as you finish off with each chapter, try doing the MCQs given in the study material as well as the descriptive questions. So meanwhile, others are just joining the class. So let us quickly have a quick revision of what we have done in the previous class by solving one or two descriptive questions. And secondly, what we're going to do today, we'll be winding up with the unit 4, that is fourth chapter, unpaid seller. It's a very small and very simple chapter. The only problematic thing is that it has too many examples to understand. So we'll try to make it as interesting as possible as we have been doing with the previous chapters. So we have done the performance of contract of sale. We have completed how the sale gets complete, how the delivery is sent, and also the last sections of acceptance was done. So we'll just quickly see few of the descriptive questions from the study material. After that, we'll be starting with my presentation about the unpaid seller. Once we have done the unpaid seller, we'll try to do question paper of 2023 and 2022 related to sale of goods as well today itself. So cooperate with me, allow me to finish off with the syllabus today as soon as possible so that we can move towards discussing the question paper also. So I hope you're excited and ready for today's class. Let's have a quick revision about the transfer of title. What are the cases where you can transfer the title even if you're not the owners? Quickly answer me that. Meanwhile, I'll just take out the descriptive questions from the study material so that we can discuss and I can find out how well you have prepared for the chapter number 3. So I'm asking you, what are the cases where you can transfer the ownership to other persons even when you're not the owner of the goods? What are those cases? Quickly answer me. Reciprocal. Mr. Kharat is asking the meaning of reciprocal means same promise that I have made you. So seller made a promise that I will sell you the goods. So he gets a reciprocal promise from the buyer that I'm willing to buy the goods. So reciprocal means to reciprocate. One has said something, you have the same, in the same sense, you have understood that and you're going to buy the goods. Possession of the goods. Mr. Suraj, possession means that you have the goods in your custody. And now ownership gets transferred when the sale is set to complete. There are two different things. One is possession, one is property. So property means ownership. I sold you the goods, you become the owner immediately. I said that you will be, I'll be agreeing you to sell the goods at a future date. So that is the case of agreement to sell. So here I'm going to give you the goods at a future date. So I have the possession of goods with myself. When the goods are given on bailment, at that time, you're just giving the possession of the goods, you're not giving the ownership. तो हिंदी में पोजेशन मीन्स जब आप किसी को गुड्स दे देते हो, उसके पास आपके गुड्स पड़े हैं बट वो ओनर नहीं है. एंड प्रॉपर्टी एंड टाइटल एंड ओनरशिप इज वन एंड द सेम. Okay, Mr. Hemant, don't worry. Let's keep it Hemant only then. You have such a big long name. Good, nice. I hope it's clear now, Mr. Hemant, reciprocal. Let's begin. मिस अंजलि अभी पूरी थिंग्स लर्न नहीं हुई हैं. सो मिस अंजलि प्लीज learn everything from the study material and try writing down the answers when you read the descriptive questions. So I'm just going to read out one descriptive question from the study material so we can have a quick revision of what we have done so far. So A, B, C are the joint owners of a truck and possession of the truck was with B. X purchased the truck from B without knowing A and C are the owners. Discuss whether the sale between B and X is valid or not. So I want the answer number question 5 with reasons from all of you. All those who have given the correct answers, that's wonderful. The answers that you have given for the transfer of title, all of you have given the correct answer. Juhi Kumari has written all the entire laws by mercantile agent, by joint owners, estoppel, all those points. Anushka, Rani Prasad, Neha Yadav, all that's good. Muskan is asking part delivery, installment delivery. So Muskan, meanwhile, others can answer me question number 5. I'm trying to take up your queries, those who have written the question. So Muskan, part delivery means where I have sent you a truck loaded with 100 bags of sugar and you have ordered for 200 bags of sugar and one truck is getting 100 bags and other is getting 100 bags. So that is delivery is coming in part delivery. So we have agreed to that. That is fine. Installment delivery means I have decided to send you 200 bags. I am sending them in part. But instead of sending it today, I said, okay, I only have 80 bags. Today you can keep it. 120 I'm going to send you after a few months. So I'm on my own, I'm saying installment delivery. So if buyer has not agreed to that, then this thing is not possible. Buyer can reject to accept the goods. Mr. Varun is asking difference between hire purchase and part delivery. So they're totally different. Part delivery means I'm sending you the goods in half of the delivery of the goods have already been given and other part is still pending. That is the agreement that the buyer and seller have had between themselves. But hire purchase is altogether a different feature, child. Hire purchase means that the goods, I'm going to giving you the goods on hire. That means on rent and you're going to pay me the rental charges. Only after all the payments have been made, then you become the owner of the goods. Anushka Raj is asking the meaning of bona fide purchaser. Bona fide purchaser is a person who is buying the goods in good faith. That means he's a valid buyer. He's not just a fake buyer. He's not a thief who's stealing your goods. He's a bona fide buyer who is buying your goods. What is the meaning of provision? Neha Yadav, provision means the law that you're studying. We are referring to a particular section. So all the acts are divided into small sections and then you have subsections. So in legal language, we refer to the provisions. That is something which is defining what the law actually says in respect of that particular section. Excellent. All those who have given valid here. Mr. Hemant, you're still not clear about reciprocal. I think you have a query related to contract act. So ask me once we are done with this chapter. What is your exact query? I'll try to explain. So it is very important that you understand, children, what you're writing. Beautiful answers given by everyone that yes, it's a joint ownership and the sale is valid because all the valid points given over there have been satisfied. He was having the possession of the goods. Buyer is not aware at the time of sale that this person, Mr. B, has no authority to sell. So there is nothing like that. He's holding it with the consent of A and C. He's having the possession. All these points are clear. Therefore, this is a valid sale. Excellent. Excellent. Mr. Yuvraj, who is asking you to learn all the sections? There is not compulsory to learn all the sections. As far as your CA foundation is concerned, children, it's very simple. CA foundation is much simpler as compared to other respective parts that you're going to do, because in CA Inter and in CA Final, it becomes compulsory for all of you to learn the sections. But as far as foundation is concerned, you can avoid learning the sections, but still I urge the students to make valid notes so that you have an understanding about what the section says. But as far as learning is concerned, it's not compulsory to learn sections in CA foundation. Never ever write a wrong section. मिस्टर दीपक कुमार, आंसर रखते क्या क्या बातें ध्यान में रखनी है जो आपने क्वेश्चन पूछा है. आज जब हम क्वेश्चन पेपर डिस्कस करेंगे जून 23 का एंड नवंबर 22 का, दैट टाइम आई विल टेल यू what all you have to keep in mind. Excellent answer, Anjali. Naved is asking the meaning of word estoppel. So today in unpaid seller again we'll use this word. So I'll explain you once again the meaning of estoppel. Yes, Varun, all the chapters have equal weightage. You cannot decide which chapter to leave, which to do. So entire thing has to be done. I don't know why somebody is sending me query from the chapter of unpaid seller. We are yet to start with unpaid seller. Let me start with that chapter and then you ask me queries. As of now, you can simply ask me queries related to chapter number 1, 2, and 3 that we have done. So Sania Khan, don't worry if you have a problem in writing. You simply have to remember this point. Okay, many of you are asking me about the problem of writing, how to practice law, Mr. Yugesh. Let me quickly tell you one very interesting fact. Children, look, if you get a straightforward question, say for example, explain the provisions related to transfer of title or ownership under the Sale of Goods Act. So wonderful answers that you have given me, 7 to 8 points that we have done: mercantile agent, buyer having the possession, buy stopple, seller having the possession, joint owners, all those points, 2 to 3 lines, all the hidden points of those points will be explained. 6 marks question, you will get 5.5 maximum, definitely. Even 6 you can get if all the points are correct. Now coming to the descriptive case study question. In case study related questions, where a case study is given to you, where a situation is given to you, you always have to divide your answers into 3 different parts. When I say dividing it into 3 different parts means the answers should have following points. That is, number 1, you will write about the concern provision. Like in the example that we just did, you will write as per Sale of Goods Act 1930. This provision relates to sale of goods by joint owners. Now I will explain the entire sale of goods by joint owners. This is the provision. These are the points which should be clarified. If it is having the position, he is having the position with the permission of the other joint owners. Buyer is a good faith. He is a legal buyer. All these points I'm writing the concerned provision. Concerned provision means act में जो लिखा हुआ है, जो उस particular section में लिखा हुआ है. Section लिखना जरूरी नहीं है, but आप provision बताओगे भी इस topic को इस provision से इसका relation है. फिर second paragraph में हम लिखेंगे facts of the case. Facts of the case, this is basically, this is the summary that we take from the question. So facts of the case is the summary of the question. I keep explaining you. English के पेपर में हमें comprehensions आती थी. क्या होता था उसमें? Comprehension होती थी. For example, Hare and the Tortoise, childhood story, where the hare and the tortoise were having a race and the rabbit slept and the tortoise came first. Snowman study wins the race, these kind of stories. And then the teacher has given you this kind of a story or a comprehension and questions were given. How come the rabbit won the race or how come the tortoise won the race? So you have to search the answer from the stories and you used to write it down. So this is what we mean by the facts of the case, writing a summary of what the examiner has given you a question. It is exactly like a comprehension. So when you make a summary, okay, these are the facts which have been given. So these are the joint owners and one of them has bowed. Now we have to discuss this case. Very briefly, you have to write. Don't replicate the question. Here is where you do wrong things. Where you're asking me now that why do we don't get marks? That is the problematic thing. So you have to write it down very, very briefly. Then comes your conclusion. So I've written the facts. You will simply write based on the above analysis and provisions, we conclude that yes, the sale made by B2C is a valid sale. B2Y, whatever was the case in that very respective case. That is how beautifully you have to write and explain the answers, students. You cannot simply say that yes, it is a valid sale. हमें पता है एग्जामिनर को भी पता है कि आपको आता है, लिखना कैसे है, दैट इज हाउ ब्यूटिफुली यू हैव टू एक्सप्रेस योर वर्ड्स. So remember these 3 points. In between unpaid seller only you have asked me this question, so I have told you. But still, once we do the question paper, how to answer case study related questions. So you can just write this frame out. Concern provision, as per the provisions of the Act, facts of the case, summary taken from the question, and conclusion based on the above analysis and provision. No one can stop you from getting full marks if you attempt your answer of the case study like this. Clear ho gaya sabko? Everyone is clear about how to attempt. Now, when we do the question papers from the examination questions, then I will make you write down this answer. As of now, just write down this, what I have written it over here. Now, I hope all the doubts of your transfer of ownership and possession are clear. Let's start with the last chapter of Sale of Goods Act, that is unpaid seller. So who is an unpaid seller? What is the meaning of the word unpaid? Unpaid means जिसको payment नहीं मिली, कुछ payment से related problematic thing है, unpaid रह गया ये. He has sold the goods, but his payment has not been made. A seller who has not been paid the full price of the goods. Now this is really bad. Mr. A sold you the goods to Mr. B for rupees 5,500 rupees. Mr. B took the goods home and later on just paid him rupees 4,000. What will you do if you're a seller, Mr. A, and there is a buyer, Mr. B, who purchased the goods? The payment was 5,500 and he only paid you 4,000 rupees, and it is a contract of sale. Do you think Mr. B has done something wrong? Yes, ma'am. 5,500 payment was to be made. He has paid him 4,000. A is having a loss of rupees 1,500. Now, before we discuss that what A is going to do, we define Mr. A as an unpaid seller because his payment is yet pending. So whenever, in case of sale of goods has been made from the seller to the buyer, and he has not received the full payment for such sale, then he is said to be called unpaid seller. Is that clear? Let me see what you have written. Okay, thank you so much. Those who have enjoyed understanding about the descriptive questions. So I hope Varun, Anuj, now the problem is clear. Case laws are easier than direct. Yes, Aditya Kumar, definitely. It becomes more easier if you write the interpretation like this. Mr. Dev Kumar, then you must practice on your handwriting, because handwriting is one thing which really bothers the examiner who is checking the question paper. If your handwriting is not good, then somebody just avoid reading those answers. So this is a very important point that you have written about handwriting. Let me tell you, children, I don't want that you start practicing calligraphy only. इतना भी बहुत सुंदर handwriting नहीं चाहिए, but हाँ, it should be clear at least. If it is not readable only, then nobody is going to give you marks, I'm telling you. Mr. M. Gora, thank you so much. Specifically, he has come to say thanks that he has cleared his foundation. All the best, Mr. Gora. I'm glad to know that. Mr. Rabi Jain wants ki ma'am sara lecture Hindi mein le lo. It's not possible. We have friends from South. They don't understand Hindi. So we have to use both the languages. Okay, Abhi? Direct questions, Anushka, Raj, then you can specifically write the questions directly from the answer. Yes, thank you, Sanya. No, Neha Yadav, you don't have to write any conclusion in direct questions. Direct question का मतलब होता है what is the difference between contract and agreement. तो आप differences लिख दो. What is the difference between sale, purchase and sale and hire purchase? So you write the points of differences between sale and hire purchase. There's no conclusion in that. Miss Mohini, you can straight away write your doubts over here. You can ask your doubts in this on the screen right now. Okay. where you have written this question, you can straight away send your doubts over here. What is tendered? Tendered means where the payment is to be made. Unpaid means buyer refuses to make the payment. Excellent. Mr. Deepak Bhai Kunwar, Sanya, Anuj, Nitisha, all of those who have written its excellent answers where the buyer is not able to make the payment. That is the place where the seller becomes unpaid seller. So, Miss Riti, keep practicing whatever we are doing in the class. I don't know why, children, are you getting so anxious? Learn ho jayega. First of all, stop worrying. Why are you having so much doubts today? Law, how will it become easy? I think you need a dose of motivation. Wait, listen, students. What you have to do is simple two things. When I'm teaching you, just keep understanding what we are doing. As of now, your chapter 3 are very, very clear. 3 chapters, sale of goods, implied conditions and warranties. Each and every doubt we have taken. Sale, agreement to sell, all those points of differences are crystal clear in your mind. You have learned them. You just need to revise them. That's why you're thinking कि अभी learn नहीं हुआ. Because we have just read it for the very first time, no? You cannot say that, ma'am, आपको सारा learn है, हमें नहीं है. Because we have been teaching you again and again. We talk to the students. So when you repeat, when you revise it again and again, you talk about it, you learn it again and again, it definitely helps you to know. But if you'll keep worrying, if you'll keep getting anxious, your messages make me feel that you're getting so worried. Don't worry. Don't I tell you and announce the name of the students who come and tell us that, ma'am, see, I've got wonderful marks. Why are you forgetting that? Try to stay positive and happy about your studies, children. It's simply 4 subjects that you have to clear. Remember, in CA, inter and final, the subjects are going to increase. How will you study then if you're just so worried today? So simple. Do your best and leave the rest on him. Always remember, he is watching your hard work. God help those who help themselves. If you have done and prepared very well, be truthful to yourself. Be honest to yourself. If you're sitting with your books, it means you should be with your books and not on your mobile with Instagram or Netflix or anywhere else. Be very, very honest to yourself. And trust me, if you study well, you make your notes, you learn it, you revise it, definitely you're going to clear your CA foundation. Bacha, bahut easy hai foundation. It's not that tough. The only thing the institute and we all require from you is hard work. सिर्फ मेहनत करनी है आपने और कुछ नहीं है. मेहनत करोगे, पढ़ोगे, समझ कर पढ़ो. अभी कितना इजी हो गया ट्रांसफर ऑफ ओनरशिप. आपको पता है, अभी फर्स्ट डे आपको ओनरशिप ही नहीं पता लग रहा था क्या है. But now we have reached a level where you know what is ownership, what is possession. When I ask you questions, you give me beautiful answers. That means you have learned it. Somewhere we have retained in our subconscious mind. Now the final revision is just pending. So keep on doing it along with the teachers. Keep on revising it. Keep on making your notes. Do it beautifully. करते रहो, करते रहो, करते रहो, हो जाएगा. And one very important thing which I tell my students, always keep saying to yourself, ho jayega, ho jayega, ho jayega. We can do it, we can do it, we can do it, we can do it, and you will do it. That's the spirit. Remember it. Try doing it. I did it this way. I used to be very scared of maths. You're writing about maths, na? You always ask about personal stories. I'll take 1 minute and quickly just wind it up. I used to be very scared of maths. So the teacher who was taking my classes for accounts, he told me, Harleen, you always come and say that, sir, I'm very scared of maths. I won't be able to clear my foundation. I used to say this every day. So he just told me one thing, that whenever you come for the class, always say that, sir, ho jayega. I will do it. And I used to laugh at him. How can you say that? I don't know maths. And he's asking me to say that, keep saying, ho jayega, ho jayega. I really used to laugh at him on this. But then I trusted him. I said, okay, let me try. अगर senior है, sir है, parents है, कुछ बात कहते हैं तो हमें मान लेनी चाहिए. So with that trust, I started saying, okay, हो जाएगा, हो जाएगा, हो जाएगा. And it happened. And trust me, it does work. But only if you're working for it. If you're just saying, yes, I will do it, but my books are closed and I'm not opening it, then nothing is going to happen. You're studying, you're doing your notes, you're making your studies. You're writing the answers. Teacher just told me this is how you have to write the descriptive questions. Now, after the class, I will take out the questions. I will write it, do my writing practice in the same way. I am studying, I'm doing everything. Definitely ho jayega. So you all have to remember and keep telling yourself, I can do it. So done. That's the spirit. We can do it and we will definitely do it. Now let's come back to the unpaid seller. Thank you, Mr. Kopala, Srinivas. All right. So now I'm not reading all those. Miss Nishita, okay. All right. That's wonderful. So let's move ahead with the unpaid seller. Thank you so much for the wonderful comments. And you are highly motivated and you have written that, yes, ma'am, together we'll do it. I'm proud of all of you. And definitely you can do it. So now once the seller has become unpaid, what is the thing that we have to understand over here is what the seller is now going to do. You have become unpaid, your payment is pending. Obviously, you'll get angry. Obviously, you feel like fighting with the buyer. So law says, I give you two different type of rights. One is your rights against the goods and another is your rights against the buyer. You have certain rights that you can enforce against the goods and certain rights which you can take the action against the buyer. You can drag him to the court. And fourth topic of this chapter is remedies against the seller, remedies of the buyer against the seller. Now, this fourth, the blue box, it talks about what the buyer is going to do if the seller breaches the contract. So quickly tell me, can the seller also breach the contract? You just answered me that, ma'am, an unpaid seller, the buyer has not made the payment. So can we say the buyer has breached the contract? You understand the word breach? Breach means that means you have not fulfilled the promise that you have made. So the buyer breached the contract by not making the payment. Can the seller also breach the contract? Can the seller breach the contract? How? How will the seller breach the contract? This is what I'm going to ask you. How can you think that the seller can breach the contract? Mr. Satya Prakash, I hope you just heard what we have just discussed. So now this will help you. And after you have done your entire syllabus, then only you should open up MTPs and RTPs, not before that. Okay, Ms. Ragini. Yes. So tell me how the seller is going to do the breach of contract. Very nice answers. Very good, because seller has not delivered the goods. Seller can breach the contract by not giving the goods, not delivered it properly. Okay, that's nice. By not giving him the goods, he accepted the money but not delivered the goods. Very good, excellent. Those who have given the non-delivery of goods. That is what is the meaning of breach of contract. Now, what will the buyer do? Remedies to the buyer means the buyer के पास क्या-क्या solutions हैं. What action the buyer can take in case the seller refuses to deliver him the goods. Very good. So in that very case, we'll understand what remedies are available. And how does the buyer breaches the contract? Buyer is breaching the contract by not making the full payment. Very good, as Sudhakar. He says, even if the descriptions is not implied conditions, if you fail to fulfill, then also he is breaching the contract. Excellent. Very nice answer. Delivery is cancelled. Mr. Suraj, that's nice. Auction sales. And then last one will be auction sales that we'll try to cover in this chapter. So I hope everyone is clear now what this chapter is overall about. Let's move to the first topic of definition of unpaid seller. So children, this is the definition of unpaid seller. If examiner asks you for 2 marks or for 3 marks, you have to write it as it is. I will explain you. It will become very simple for you. And once it has become easier and you can express it in your own language, you must give an example also. So like this, we'll give an example. So your unpaid seller definition will become crystal clear and you have to write it as it is in the examples. So the number one thing is whole of the price has not been paid or tendered. So those who are asking the meaning of tendered means to do it. So to make the payment. So that means has not been tendered means has not been paid, or you can use the word has not been paid. So tender of performance, remember under performance of contract where you're going to trying to perform the contract. So where the price has not been paid or you have not made an effort to pay the price, seller will immediately get the right of action for the price. He will immediately file an action against you. Either he will use his rights against the goods or he is going to use his rights against the buyer. What are these rights? I haven't told you yet. I am just telling you what happens, how you become the unpaid seller. So number one, whole of the price is not paid. So my question to my students is 1,000, the goods were for rupees 1,000 and the buyer paid you 9,900 rupees. So do I become unpaid seller? Yes, ma'am, or no, ma'am? Buyer has made me the payment of 9,900 rupees. Oh, sorry, 990 rupees. The goods were for 1,000. You have paid me 990 rupees. Do I become unpaid seller? Yes or no? जल्दी से बता दो मुझे. मिस्टर दिवाकर, हिंदी में इसका मतलब होता है कि बायर ने मेरे पैसे नहीं दिए तो सेलर अनपेड सेलर बन जाएगा. ओके. Mr. Suraj is saying when the seller makes fraud in delivery. So when we go to the remedies of buyer, I'll explain you how the fraud can happen. Yes, ma'am, he becomes unpaid because 100 rupees are due. Very nice. Even if 1 rupee is pending, then also you become the unpaid seller. The first point is 100% clear. Now the second one is very, very interesting. Where the bill of exchange or promissory note or any other negotiable instrument has been received as a conditional payment and it has got dishonored. So here whole of the price was the main line. Here the dishonoring of the bill is main line. Now what is the meaning of this line, ma'am? हमें तो समझ ही नहीं आया ये क्या लिखा है इंग्लिश में कि बिल आया डिसऑनर हो गया. So let's see example number 2. A was the seller and B was the buyer. Here B was giving him cash payment of 1,000, but B said, I don't have a cash. I'm going to give you a check of rupees 1,000 rupees. Now what happens when A gets the check? He will go to the bank and he will deposit this check. How does negotiable instruments function? Negotiable instruments means a bill of exchange, promissory note, and check. Once we are done with sale of goods, in the next class, day after tomorrow, we're going to start with the partnership. So please revise your sale of goods. Till tomorrow, I'm giving you the time. Revise and learn each and everything of sale of goods. It's completely done because on Thursday, we're going to start with the partnership. So after partnership, you will be doing your negotiable instrument also because it is a part of new syllabus. So negotiable instrument, you will be doing it in detail, but basically it means 3 types of negotiable instruments we had. It is a mode of payment for buying the goods. So if you have purchased the goods, I don't have cash, I'm either paying you through a bill of exchange or I'm raising a promissory note. Promissory note means where I'm promising to make you the payment at a future date. Or I'm making you the payment of check. So check is something which you all are very familiar. You have been hearing the word check from your business studies days. So let's take an example of check. So now A went to the banker and he deposited this check. Now, what will the bank do? Bank will withdraw 1,000 rupees from B's account and it will get credited to A's account. This is the transaction of check. आपको किसी ने चेक दिया, आपने बैंक में चेक लगाया, उसके अकाउंट में से डेबिट हो जाएंगे और आपके अकाउंट में क्रेडिट हो जाएंगे. But what happened when the bank, this check was given, this check got dishonored. Why? Because B was only having 20 rupees in his bank account. Can I get the payment of 1,000? What will happen? The check will get bounced now. If the B is not having sufficient funds in his account, then the check gets bounced. That means it will get dishonored. Say, for example, B had 20,000 rupees in his bank account. Then now what will happen? A will get 1,000 and B will be left with 19,000 rupees. This is how the transaction of banking works. Journal entries, accounts, you all know this. So now if there is no payment only, how will 1,000 be withdrawn? He only have 20 rupees in his account. So the check will get dishonor and this angry Mr. A will again become the unpaid seller. क्योंकि मेरा तो पेमेंट ही नहीं हुआ. अब चाहे वो पेमेंट कैश में था तो आपने कैश नहीं पे करा तो मैं अनपेड सेलर बन जाऊंगा। अगर मेरा पेमेंट चेक में होना था एंड वो चेक हो गया है डिसऑनर्ड, देन ऑल्सो आई बिकम अनपेड सेलर। इज दिस क्लियर टू एवरीवन? Well done if it's clear. Let's see the examples over here. So A sold certain goods to B for 50,000 and B paid him only 40,000. He fails to pay the balance amount. लिखा होगा क्वेश्चन में। एक होता है इंस्टॉलमेंट्स में पेमेंट करना, एक होता है फेल्स टू पे। फेल्स टू पे मींस नहीं दिया बाकी पैसा, तो A will become unpaid seller. Another example, P sold the goods to R for rupees 60,000 and he received a check. On presentation of the check, you can see the beautiful pictures where cash is being given, where the check is being given. The check got dishonored. Got dishonored means it got bounced. There was not sufficient account money in ours accounts and we cannot get the payment. Therefore, now again, I will become unpaid seller. Clear ho gaya? Now, what are the rights of this unpaid seller? What will happen when I become the unpaid seller? Now, let's try to solve the mystery of this unpaid seller. What are the rights available with him? Now, what are the rights of the unpaid seller? There are two different types of rights. One where the property has been passed, another where the property has not been passed. What is the meaning of where the property has been passed? Means it is a contract of sale. And what is the meaning? What do we call this, children, where the property has not been passed? What is this kind of arrangement? Good, good, good. Those who have written correct answers, in that case, he becomes unpaid. Very nice. Very good, student. That means my class is totally attentive today. Beautiful. Yes, now tell me, students, what do we call when the property has not been passed? I said property was passed, so it is a case of sale. I'm waiting to announce the name of the student who gives me the first correct answer. When the property has not been passed, it is known as Mr. Shubham Sharma, Anand Sahu were the first ones to send the correct answer. It is known as agreement to sell. Beautiful. And after that, followed by everyone, Anushka, Muskan, Aditya, Dev, Anshu, Joya, Naved, Rani, Kinchal, Anush, Madhu. Oh my God, so many of you. Everyone has given the correct answer. It means agreement to sell, which is again a future date sale. So now in both the cases, I have my right against the goods. This is what this line is saying. And I have certain rights against the buyer. Can you see this happy buyer over here who is smiling? That yes, yes, I will make you the payment of the goods. And once you don't pay me my goods, I will drag you to the court. And why this picture of drawer has been shown and the keys are kept over here? Because I am going to use my rights against the goods, means that seller will take his goods back. Either he has the goods lying with him, which he's not going to give it to you now because you have failed to make my payment, or I've given you the goods, I will take them back from you. And I'll hide them in this drawer and pack them and keep the keys with myself. I will not give you the goods if you have failed to make my payment. Either it is a case of sale or an agreement to sell. In both the cases, I can exercise my right against the goods. What are my rights against the goods? These are the rights which are available to me: right to lien, right to stoppage in transit, and right to resale. However, if the property in the goods has not been passed, so here you can simply write down these are the rights available to unpaid seller in case of a sale. 3 rights are available. In case where it is an agreement to sell, where I had to future sell you the goods, I have 4 different rights if I become unpaid. The only additional right is withholding delivery, which is also known as quasi lien. Don't worry, we have all these terminologies covered in study material. I'll explain you. Abhi ke liye sirf itna likh ke rakh lo. Withholding delivery is also known as quasi lien. Quasilien. Quasi lien. Now, what is the meaning of right to lien and stoppage in transit? We will first type of right we will do and then we'll take a break. Let us understand what is the right to lien on the goods. Seller's lien means right to retain the possession of the goods. Now you remember this picture of drawer that I have kept over here? Let me give you a very interesting example. A sold the goods to B for rupees 5,000. A sold the goods to B for rupees 5,000, and these goods are still lying with A. He said, once you make me the payment of 5,000, come and take your goods. This Mr. B came and he paid him rupees 4,000, and he said, give me my goods. So you tell me, as an honest person, if you are the seller and I am the buyer, I give you 4,000 rupees instead of 5,000. Will you give me the goods? What will you do? If you are the seller, I had to pay you 5,000. Mr. Varun, why are you asking meaning of transit? I have not yet done it. Be here what we are doing right now. बच्चे जो पढ़ रहे हो पहले उसको समझो, फिर नेक्स्ट टॉपिक पे जाना है, फिर बड़ी मुश्किल हो जाएगी वरना आपको. Okay? And somebody is asking what is right to learn. That is what we are discussing right now. So listen, we are going to do it very slowly so that you understand each and every point. So quickly tell me, if I had to pay you 5,000, I only give you 4,000. Will you give me my goods or not? Batao. Jaldi batao. Will you give me the goods or not? No, ma'am. No, ma'am. We will not give you the goods. No, no, no. What will you do with the goods then? What are you going to do? डिस्काउंट दे दोगे? एक बच्चा कह रहा है मैम डिस्काउंट दे देंगे. तो डिस्काउंट की बात नहीं हो रही है यहाँ पे फाइनल रेट है 5,000. डिस्काउंट होता तो वो अलग बात. Here I'm saying the goods are sold at cash payment and 5,000 was to be made. Let's take the first example of cash sales. So, but I have only paid you 4,000. So very rightly mentioned, no ma'am, we will not give you the goods. I will keep it. I will not give it. And then only when you make me this payment, then only I will give you the goods. Very nicely you all have written. So as a layman, you understand that you will not give the goods. The law calls this right to retain the possession of goods. जो आपने हिंदी में बोला कि मैं आपको गुड्स नहीं दूंगा, उसका इंग्लिश में मतलब होता है कि गुड्स को रिटेन कर लेना, अपने पास रख लेना. जो हिंदी में मांगते हैं इसका मीनिंग अपने पास रख लेना. गुड्स को रिटेन कर लेना मीन्स अपने पास रख लेना. अब इससे ज्यादा हिंदी नहीं हो सकती है, समझने की कोशिश करा करो. अपने पास रख लेना गुड्स को, लियन एक्सरसाइज कर लेना. माय इंग्लिश फ्रेंड्स, when I have not made you the full payment, definitely you all said that ma'am we will not give you the goods. So that means in English we call it, in law we call it that now I'm going to retain the possession of goods, means I will keep the goods. I will keep the goods to myself. Seller is going to keep the goods with himself. He will not give you the goods. Till what time? Till you make my full payment. But this is what the right to lien is. Word बड़ा tough लगता है, right to lien, seller's right. It has a very simple meaning that he has right on his goods. I sold you this water bottle. You said, I said this is for 800 rupees. You came and you paid me 750. I will not give you the water bottle. This is my water bottle. I asked you to pay me 800 rupees. You have not paid me. I will keep this water bottle in the drawer and I have exercised my right to lien. I can exercise that right to lien because this is my good. I am having its possession. But once I have given you this water bottle and then you fail to make my full payment, then I cannot exercise because goods मेरे पास होने चाहिए. I should have the goods in my custody, my possession. Possession means custody of the goods. I should be having the custody. They should be with me. Then only I can exercise the right to lien. Very important point. लिख लो यहाँ पे. Right to lien can be exercised only if seller has the goods with him. Mr. Preetham, don't worry. Even if you're doing it from now, you will understand. Don't worry. Okay. I hope, Ragini, now you have understood. We just explained in Hindi also. Yes, Madhu is also saying, I will keep it to myself. I will not give it to the buyer unless he make my full payment. All of you have given wonderful answers. Mr. K. Manish Darshan says, I have understood it very clearly now. Great. I'm glad. So you can exercise the right to lien only if the seller has the goods with him. So we all have understood the meaning of right to lien means I will retain the possession of the goods unless and until you not make my payment, I will not give you the goods. So when can I do this? Number one, I can do it in the case of cash sales. Cash sales means you have made an agreement to pay me cash. You have not paid me cash, so I will not give you the goods. What is the meaning of credit sales? I said, okay, I am giving you a credit period. Make me the payment in next 3 months. Now, 4 months have passed. Expiry of credit period has happened. I will again keep the goods to myself. I will not give you the goods because I gave you a period of credit sale. उधार पे देना. Credit sale mean उधार पे सामान बेचना. तो आपने उधार की पेमेंट 3 महीने में चुकानी थी. आपने 4 महीने बीत के अभी तक पेमेंट नहीं दी तो मैं आपको गुड्स नहीं दूंगी. If the credit period expires and still you have not made me the payment, I will keep the goods to myself. Or the buyer has become insolvent. When do you become insolvent? He ceases to pay the debt in the ordinary course of business. It means that now his assets are not sufficient to pay off his liabilities. दिवालिया निकल जाना, इंसॉल्वेंट डिक्लेयर हो जाना मींस अब मेरे को कोर्ट ने इंसॉल्वेंट डिक्लेयर कर दिया, मेरे पास पैसे नहीं है अपने लाइबिलिटीज को पे ऑफ करने के लिए. अगर ऐसा बायर है, सपोज ए सेलर है, बी बायर है, ए ने गुड्स बेचे हैं 10,000 रुपीज के बी को, पेमेंट इज पेंडिंग एंड ए इज हैविंग द गुड्स विद हिम. वेरी इंपॉर्टेंट लाइन ना, सेलर शुड बी हैविंग द गुड्स and now A came to know that B has become insolvent. Will I give the goods to B? No, ma'am, I will not give. I know that he has become insolvent. His official assignee is going to pay me a ratable dividend. I don't know how much liability he is having on his head, whether he'll make my payment or not. Better not to give him the goods. So बात ही खत्म. 10,000 के गुड्स बेचे थे, पेमेंट तो वैसे ही नहीं आई, गुड्स भी नहीं देंगे. इंसॉल्वेंसी के केस में सारी बात खत्म. आई विल कीप द गुड्स इन माय ड्रॉर एंड द कीज विद माय सेल्फ. आई एम नॉट गोइंग टू गिव यू द गुड्स बिकॉज यू हैव बीन डिक्लेयर्ड इंसॉल्वेंट. So what are the 3 cases in which I can retain the goods? Number one, cash sales, and you do not pay me the full cash, I will not give you the goods. Why 5,000 ka 4,000 wala example. Credit sales, I have given you the credit period of 3 months. 4 months have expired. You've still not made me the payment. I will not give you the goods. And third case, where the buyer has become insolvent. I trusted you. I gave you a time period to pay me for my goods, but now you have been declared insolvent by the court. So you don't have sufficient money to pay. So you will not be paying for my goods also. So I will not give you my goods. Clear ho gaya? Now let's come to part delivery. Seller can exercise his right to lien on the remaining goods if part delivery has already been made, unless the part delivery means waive of lien. So waive of liens means sometimes I waive off my lien. I give up my lien only, that I am not going to take the goods back. So waiver is a different meaning. But let's understand the word of part delivery. So where in the beginning of the class, I told you that A is sending 200 bags of sugar. One truck is bringing 100 bags of sugar. Another truck is bringing 100 bags of sugar. So B received one truck which has got 100 bags of sugar, and he called up A and he told him that I will not be able to make you the payment. Can I exercise the right to lien on these 100 bags? No, ma'am. B has already taken these 100 bags. How can you exercise the right to lien? Lien तो उसी के ऊपर होगा जो आपके पास है. So law says in case of part delivery of goods, the goods which have already been delivered to the buyer and he has taken those goods, on those goods, I cannot exercise my right to lien. But the remaining goods, I will quickly call the truck driver and I will tell him, please bring my goods back because buyer का phone आ गया, वो payment नहीं करने वाला. So now I will retain these 100 bags. I will not give it to him. So where right to lien can be exercised on the remaining goods if the seller comes to know that he has become unpaid seller. Okay. Thank you so much, Mr. Divakar Kumar. Mr. Faisal is asking, what is the meaning of stipulation? Good morning, Mr. Faisal. You're still in the second chapter. Stipulation means the representations which are given by the seller to the buyer to influence him in order to make his sale. साक्षी वेवर का मीनिंग अभी करेंगे हम. Okay. cash sales, credit sales, insolvency, excellent. Miss Ragini, I hope you have understood now. All right. So part delivery, everyone is clear now about part delivery. So where I have delivered the goods, buyer has already taken the goods. On those goods, I cannot exercise my lien, but on the remaining goods, if I come to know that the buyer is not going to make my full payment, I can exercise my right to lien. Now, what is the meaning of waiver of lien? I will explain you what is the meaning of waiver of lien. So this we will understand in this next slide. What is the meaning of waiving of lien? Waiving of lien का मतलब होता है, you remember when I waived off my breach of condition, I gave up my right. Waive off means to give up your right. I am waiving off this condition. I have given it up. Okay, I am not going to take the goods back. So where the seller has already implies part delivery means waive of lien means where I have told you expressly that okay, fine, I'm not going to take my goods back, then seller cannot take his goods back. So how does the lien comes to an end? It says seller's lien termination means how does this lien comes to an end? What are the cases where I cannot exercise the right to lien means right to retain the possession of goods? Number one, where I've given the goods to a carrier or a bailiff for transporting the goods to another place. So now you remember section 23 subsection 2. अब बोलेंगे मैम आपने तो कहा था सेक्शन नहीं लर्न करने, तो हमने नहीं करा. बट ये तो याद है ना कि उसमें मैंने आपको बताया था होता क्या है. अनकंडीशनल एप्रोप्रिएशन ऑफ गुड्स, where I've given the goods to a carrier and I've told him that I'm not reserving my right to disposal. You take the goods and give it to the buyer. Now, once the goods have gone out of my custody, they have already been uploaded in a truck and they're going for transportation. I cannot exercise my right to lien. I can only exercise the right to lien if this bottle is with me or if these goods are with me. Once I have loaded it in the truck, it is out from my possession, my right to lien will come to an end. I do have other rights also, but as of now, राइट टू लियन की बात हो रही है. तो क्या मैं लियन एक्सरसाइज कर सकती हूँ? क्या मैं रिटेन कर कर अपने पास ड्रॉर में रख सकती हूँ? नहीं रख सकती हूँ, क्योंकि मैंने गुड्स ऑलरेडी ट्रांसपोर्टर को दे दी. If buyer or lawful agent obtain the goods, so buyer has already taken the goods, then also my right to lien will come to an end. By waiver means I expressly told him that okay, I give up my right. I have expressly given up my right. Given up means I said okay, fine, I'm not going to take back the goods. Even if you will not pay me the money or some problem will happen, I will not exercise lien on the goods. I have waived off my right. I might drag you to the court. I might take another action, but I will not exercise lien. I have given up my right of exercising lien on the goods. Understood? The means of waiver means to give up. I will not be doing my lien exercising of lien on the goods if payment is not made. Now the word estoppel, those were asking. Estoppel means if somebody stays silent in front of the real owner, then it was presumed that he becomes the owner of the goods. So I am trying to sell you the goods and the real owner is standing and he does not say that, no, he is not the owner, I am the owner. Then in that case, I will presume to be the owner of the goods. Similarly, under estoppel case, let's take a very beautiful example. A sold the goods to B. So here was Mr. A. He sold the goods to Mr. B. A is the seller, B is the buyer. And B in front of A sold these goods further to C. So C is the sub-buyer who's buying the goods. So now A is looking at Mr. B that he's selling the goods to Mr. C and he knew that his payment is still to be made. But he's having full trust and faith on B that, okay, fine, B, you can sell the goods to C and you make me the payment whenever you want. Now, goods have already been sold from B to C. Do you think A can exercise his right to lien on these goods? He cannot exercise his right to lien. Why? Because by his conduct, by his estoppel, he has given up his right to lien. He has permitted B to sell the goods further to C. He has agreed that, okay, fine, B, आप मेरी बाद में payment कर देना. You can pay for my goods later on. He has agreed to this statement. Now his lien has come to an end. The goods have already been given from B to C. Valid sale has been made with the permission of seller A. Therefore, his lien will come to an end. So let's have a quick revision. Lien means that I can, once I become an unpaid seller, when do I become an unpaid seller? When my whole of the price has not been paid, or the payment was to be made through check or bill of exchange and the check got dishonored. In both the cases, I become unpaid seller. Once I become unpaid seller, I have certain rights against the goods, against the buyer. We are not doing away against the buyer. We are doing the rights against the goods. Out of those rights against the goods, the first right is right to lien. Right to lien means that the seller can retain the possession of goods. He can keep the custody of goods with himself unless and until his payment is made. Fine. I can do these in three cases: cash sales, credit sales, and if the buyer has become insolvent. In all these three cases, I will keep the goods to myself if my payment is not made fully. When do I cannot keep the goods in my custody? When does my lien gets terminated? When does my lien comes to an end? Number one, when I've given the goods for transportation to the carrier or the bailee. Number two, where the buyer has lawfully taken my goods. He came to my shop, I have packed 100 bags of sugar, he has taken the goods home, and now if he fails to give me the money, I don't have the goods, buyer has the goods, I cannot exercise my right to lien. Simple. By waiver, when we made an agreement, I waived off my right. I said, okay, fine, buyer, I am very happy with you. You make my payment, but I am not going to exercise my right to lien. I have given up that right. I have waived off that right. Remove कर देना, हटा देना, waive off कर. ठीक है? So now I do not exercise my right to lien because I waived off. Number fourth, where by estoppel or conduct I have given up my right on lien. That means I am the seller. In front of me, the buyer is selling the goods to another sub buyer. I have given him permission to do that. My payment is still pending. But once the goods from the buyer to sub buyer has gone, I cannot exercise my right to lien on those goods. क्लियर हो गया? ब्रेक लेते हैं 5 to 7 minutes की. फटाफट से राइट टू लियन एंड अदर पॉइंट स्टडी मटेरियल में से रीड करो, एंड आफ्टर द ब्रेक वी आर गोइंग टू रीड इट फ्रॉम द स्टडी मटेरियल इटसेल्फ. लेट्स टेक अ स्मॉल ब्रेक. All right, welcome back, students. So Ms. Joa Praveen is asking, in part delivery, if the goods are with the truck driver, can we still exercise the right to lien? So when the goods are with truck driver, we will be exercising a different right, that is right of stoppage in transit. So what is the meaning of stoppage in transit, which is the second right, which is just coming up? Stoppage means to stop. In transit means that the goods are still traveling from one place to another. So very right question she has raised, that ma'am, how can we do right to lien because the goods are already in transit? So the moment I will come to know that my goods have been parted with me and the buyer has become insolvent, I'll call the truck driver. I'll tell him, please bring back my remaining goods. And now, after taking the goods back from him, I regain my possession and I will keep it to myself. I will exercise my lien as well on these goods now, because I have come to know that the buyer is not going to make the delivery for the part of the goods. Mr. Divakar, don't worry. Even if once you have watched the classes, you make your notes and you can also study the previous that you have missed out from the sessions which are already on YouTube, and accordingly make your notes from those classes. Yes, Mr. Amal PR, you can definitely write it in your own words also, the examples we are doing, but it's not necessary to write all the examples in a particular context. You have to read the question very carefully and answer accordingly. What is the meaning of decree of price? So we are just going to open the study material. I'll explain you. Subject to the provisions, Mr. Vishnudeo Thakur. Subject to the provisions means that with respect to this thing. So whatever is written in that particular provision, that gets superseded when you write the word subject to this provision. That means we are talking in context of this kind of provision. Let me just open the study material for all of you, and we can see each and every line which is given, as we always do. After the doing presentation, we always take each and every word from the study material. So here we have opened the study material. Let me see if all the doubts have been clear. Yes, Mr. Deepak Kumar, if the goods are in transportation, we can use the second right, which I'm just going to explain you how we can use that right. Miss Palak, the same question you were asking. Once we have taken the goods, once we have given to the transporter, we can take back the goods from him as well. That is the second right. All right. Lien means the right to retain the possession of the goods, right to keep the goods with himself. Mr. Abhay Jain, waiver means that seller has given up his right. He do not want to keep the goods. He has himself told him that I have terminated my right to lien. I have given it off means I have told him that I will not be retaining the possession of goods. Thank you, Mrs. Shanti SK. I'm so happy the classes you're finding so helpful. That's great. Miss Riti, definitely the goods which have already been taken by the buyer, you cannot take the goods. So the 100 bags which have already been taken by the buyer, that you cannot take it back from him. For that case, you can exercise other rights, which I'm going to explain. Mr. Hemant HK, if it is a credit sale, then I have given you certain period for the credit. And after that credit period has expired, still if you don't make my payment, I will keep the goods to myself. Definitely, Mr. Amal PR, we'll do the previous question paper as well. But once we have to complete the syllabus, then only we can go to that. Okay. Unpaid seller definition we have done. I hope no doubts in this point. Seller is a person who the agent to whom the bill of lading has been endorsed. Now, this is very interesting. Seller means any person who is in the position of a seller, even the agent of the seller to whom bill of lading has been endorsed, or a consignor or agent himself. So somebody from whom you have purchased the goods to whom the payment is yet to be. That is the person who is the seller. These are both examples which I've covered from the presentation as well. The right to lien, again, the same points. When he's in the possession of them in case of insolvency, and right to resale, we are yet to do that. So these are the categories of lien. Seller's lien means refusal to deliver to the buyer. Very important line. Please mark it important. Lien means when you retain the goods and you refuse it to give it to the buyer unless your interest payment has been paid or tendered. It is one of the same thing. Tendered. Tendered means to pay. So, but lien can be exercised as long as the seller has the possession of goods. Possession है उसके पास तभी वो lien करेगा. अगर possession ही नहीं है, possession means अगर उसके पास goods ही नहीं है, फिर वो lien exercise नहीं कर सकता. Okay. Let's move further. A sold the goods for 50,000 and allow him to pay price within 1 month. So I have given him the credit period. You all know why you asking what is the meaning of credit period. Cash sale होती है, credit sale होती है. Cash मतलब cash पे payment immediately करनी है. Credit मतलब उधार का period दिया हुआ है. अब जब credit period था, B became insolvent. Therefore, A has become unpaid seller. He can exercise his right to lien. I hope example number 3 is absolutely clear. Part delivery also we have done. Termination of lien, this we have discussed, section 49. That means now the seller himself made it to believe to the third party. Who is the third party in this case? C, the sub buyer. That lien does not exist. We have not stopped him, B, from selling the goods to C. Therefore, now I lose my right to lien. So termination का दूसरा easy meaning क्या है? Loses his right to lien. Means he cannot exercise his right to lien. Unpaid seller having lien does not loses right. Now, this is very, very important and you keep asking me. That's why I have included the meaning of this line over here. Unpaid seller having a lien does not lose his line because he has obtained a decree for the price of the goods. So decree means court's order. It means court's order. Sometimes what happen is, now listen to the story carefully. Sometimes what happen is A and B are having a fight, buyer and seller. Buyer says, I will pay 5 rupees. Seller says, no, you should pay 6 rupees. He says, no, I will only pay 5. And both of them went to the court. Court says, neither buyer nor seller, you have to pay him 5.5 rupees. So now court has given the order to A that for the price money, for these particular goods, the reasonable price for the particular good is 5.5 rupees. Now A has this order from the court. This is known as decree for the price of goods. Means court का order आया हुआ है कि आपका इतना ही price देना पड़ेगा उन goods के लिए. Now, even if the seller has taken the price under a court case, he can still exercise the right to lien on those goods. अब हुआ क्या? इस story में what happened is A and B were having a fight. They went to the court. Court fixed the reasonable price of 5.5 rupees. Now, B failed to make the payment. Can A exercise the right to lien on the goods? Law says yes. Right to lien can still be exercised. Even if the price for the goods which has to be paid has been taken from the court's order, but right to lien, it has nothing to do with the right to lien. Right to lien can still be exercised. In Hindi, अगर आपकी लड़ाई हो रही है बायर के साथ प्राइस फिक्स करने के लिए, तो जो भी आपका प्राइस फिक्स हुआ है कोर्ट केस में चला गया, कोर्ट ने ऑर्डर दे दिया. डिक्री ऑफ द कोर्ट मींस कोर्ट ने एक ऑर्डर निकाला है कि आपके गुड्स का प्राइस ये होगा, सपोज 5.5 रुपीज. अब बायर ने वो 5.5 रुपीज देने से भी मना कर दिया, तो सेलर राइट टू लियन फिर भी एक्सरसाइज कर सकता है गुड्स पे. उसका ये हक फिर भी रहेगा गुड्स के. समझ गए? हिंदी इंग्लिश बोथ क्लियर? थैंक गॉड. So decree means court's order, and write down this example that I've just explained to you in your own words so that you don't forget what is the meaning of right to lien in case of decree of the court. Now, example number 4, my question to my dear students is, A has sold the car for 1 lakh and he has given it to the railways for purpose of transmission to the buyer. So that means railways is going to take this car. That means the buyer is not in the same city. We have to transport the car through the railway authority. And the railway receipt was taken in the name of B. A cannot exercise the right to lien. Is this correct? Example number 4. Bacha, he is telling me that now I cannot exercise my right to lien. Is it correct? Yes, ma'am, or no, ma'am, and why, ma'am? If it is correct, I want to know the reason why. Why I cannot exercise my right to lien? Under which category this lien has come to an end? Tell me. Example number 4. Why A cannot exercise his right to lien on the goods? Yes, Sanya Khan, you can prepare the notes from my presentation. That's fine. Anil, I hope our delivery is now clear. Thanks, Riti. Anushka, credit sales mein goods will be delivered to the buyer. Yes, Anushka Raj, why not? In case of credit sales, the goods were to be delivered. If you don't make my payment, I will not give you the goods. Yes, Mr. Thakur, if the physical possession has not been given, then only you can exercise the right to lien. Ansh is saying because it is a constructive delivery. Oh my God, no. Constructive delivery nahi hai, symbolic delivery hai. Where I'm giving a bill of lading, a bill of railway receipt, then it is a symbolic delivery. Property in the goods has not been passed, physical goods. Okay. Sakshi says, yes, ma'am. He cannot exercise his right to lien. Shanti says, because the goods are dispatched under the name of buyer. Why? Because you've already dispatched the goods. You've already given it to the transporter. You have already given it for the transmission to the buyer. So once you have given because category first will apply. Excellent, Miss Divya. So once you have given the goods to the carrier, bailey for transporting, you have lost your right of lien. So Khushi, Mohammed, Shanti S, Sanya Aditya, Sakshi, Ansh, Mr. Thakur, all of you are correct. Renuka, Joya Parveen, Mr. Ansh, Monu Singh, Anuj S. Sudhakar, Riti, all of you are correct. Correct answer. Now let's move to another right, that is right of stoppage in transit. Now what I can do is, in example number 4, I cannot exercise my right to lien, but I can exercise my right of stoppage in transit. I just now explained you, if my truck driver is or my railways are taking my goods, I can call the railway authorities. I can inform them that, look, buyer has become insolvent. He is not ready to make my payment. He will not be able to make my payment. Please hold my goods. Stop them in between. Now, that does not mean that you're going to go and pull the railway, the chain in the train and the goods will stop. Somehow, some discussion has to be done with railway authorities. They will either take the goods in their own custody and seller can quickly run and take his goods back. All right. So that is what right we can. He's lost his right on the goods. Mr. K. Manish Darshan, that's great. But now he can exercise his right to stoppage in transit. Mr. Ayush Kumar, बिल्कुल ठीक बोला आपने. Motiani, and refuse the house seller has the right to determine the prices. Mr. Motiani, with the price is fixed by court's order. So what is the exception trying to explain you under section 49? That if the court has fixed the price, then also the right to lien still remains with you, provided you have the goods. So now this is a very common sense question. I told you we have written that bold line also, that right to lien will only be exercised if we have the goods. If I don't have the goods only, then right to lien cannot be exercised. Then you can use the other two rights, which we are just going to do now. All right. Now let's proceed further. The right to stoppage in transit means stopping the goods while they're in transit and regain the possession and retain them. So once I regain it, I retain them, put them back in my drawer till my full price is paid. So there are two different words, retain and regain. One is to retain the possession of goods. Retain means I have the goods and I keep it with myself. मेरे पास ही थे, मैंने अपने पास रख लिए, retain हो गया. What is the meaning of regain the position? You tell me, hurry up. What is the meaning of regain the position of goods? Regain means seller has parted with the goods and then call the truck driver or whosoever or carrier or bailey and ask him to bring back the goods. This is how he regained the possession. Regain मतलब कर लेना वापस ले लेना. हिंदी में भी लिख दूं आपके लिए, वापस ले लेना. ठीक है, वापस ले लिए मीन्स हमने रीगेन कर ली पोजीशन. रिटेन मीन्स मेरे पास ही थे, मैंने अपने पास रख लिए ड्रॉर में, and we have kept the goods to myself. Regain means I have parted with the goods, I have given to the transporter, now I came to know, so now I regain. In stoppage in transit, we are regaining the position. In case of right to lien, I am retaining the possession. Is that clear, students? So unpaid seller has parted, the buyer has become insolvent. So what are the conditions? Let us see the conditions. Number one, seller must be unpaid. When do you become unpaid? When number one, either the buyer has refused to make you the payment or the check has got dishonored. Both the cases, yes, ma'am, we know why he becomes unpaid. He must have parted with the goods. Can I exercise right to stoppage in transit when the goods are lying in my shop only? Why do I need to exercise stoppage in transit? They are in my shop. I will exercise my right to lien. So stoppage in transit comes in picture only when you have parted with the goods. Parted हिंदी में जब आपने goods दे दिए किसी और को, उनके साथ आपकी दूरी हो गई है, पार्ट हो गया, आपसे दूर चले गए goods, तभी आप stoppage in transit करोगे. So you must have parted means you have given away the goods to the carrier or transporter. The goods are in transit. Very, very important. They should be in transit. Children, if buyer has already taken the goods, they have reached their destination. Mr. Buyer is standing over there. He has taken the goods. Can I stop in transit? No, ma'am. Then you cannot stop in transit. Only while they are in the travel period. Then only I can stop them in transit. Buyer has become insolvent. Very important condition here. The buyer should have become insolvent. Then only you can stop the goods in transit. And this right is subject to provisions of this act. Subject to provisions of this act means whatever is written under the Sale of Goods Act, accordingly, this right has to be exercised. For example, where you have parted with the goods and the buyer has become insolvent and the goods have already been delivered to that buyer, then you cannot take the goods back because the goods should be in transit. So whatever other provisions are applicable, that has to be kept in mind while applying this act. This is the meaning of right to subject of provisions. And somebody who was asking the meaning of reciprocal again and again, reciprocal means I am ready to sell you the goods and you are ready to buy the goods. That is, both the parties should be acting in the performance of contract. A of Mumbai sending the goods to B of Delhi. He delivered the goods to a common carrier C. C is the transporter over here. Before the goods could reach means, ma'am, the goods are still in transit. The third point is correct. The goods are in transit. Has the seller become unpaid? Yes, he has become insolvent. Therefore, A becomes unpaid. He has parted with the goods. Yes, he has given the goods to the common carrier, Mr. C. Buyer has become insolvent. Yes, ma'am. Now A can stop by giving a notice of it to C. So he will call Mr. C. Look, my goods, I have already, given it to the transporter, Mr. C, I've given it to you. B has become insolvent. Please bring my goods back. So it is C's duty to get the goods back because now the buyer has become insolvent and he cannot give the goods to him. The goods are deemed to be in transit when they are delivered to a carrier for the purpose until the buyer has taken the delivery. Means जब तक buyer delivery नहीं लेगा उसे duration of transit ही माना जाएगा. Simple. You tell me, children, I have sent the goods from A in Delhi to B in Pune. B in Pune has received the goods. B in Pune has received the goods. And now he fails to make my payment. Can I exercise my right to stoppage in transit? Thank you so much, Mr. Varun Bapri. Your beautiful comments make us stay more motivated. Thank you so much. He said, I like law because of your teaching style. And thank you all those who have written that, ma'am. We are enjoying the examples along with this topic. So thank you. S. Sudhakar says, yes. Okay, please tell me now. Will you exercise the right to stoppage in transit if Mr. B has received the goods? फिर से gain होना रीति, yes. Profit होना means फायदा होना. Good. Miss Renuka, that's correct. S. Sudhakar, that's correct. Anuj, Kushi. Miss Kushi Chaudhary, you can send your query again. Yes, your name is visible over here. Don't worry. No, ma'am, he cannot take because the transit has come to an end. Wonderful answers given by all of you. That's great. So now let us see, when does the transit comes to an end? What are the cases when the transit comes to an end? Number one, when the buyer takes the delivery. Abhi aapne samajh liya. Buyer takes the delivery before the arrival of goods at destination. This is very, very interesting. So buyer was very curious to take these goods. Before they reached Pune, he went in between and he said that please give my goods. I want to take it. So once he has taken it, whether in between or on reaching the destination, right to stoppage and transit comes to an end. Where the bailee acknowledges to the buyer that he holds the goods as soon as the goods are loaded on the ship, unless the seller has reserved the right to disposal. Now, this is specifically section 23, subsection 2, where I have not reserved my right to disposal. The buyer becomes the owner immediately. Remember, once we have given the goods to the transporter for taking, any damage happened, buyer was held responsible. Why? Because it was unconditional application. But where I am reserving my right to disposal, their seller only remains the owner, then the goods can be taken back anytime. If the carrier means transporter, wrongfully refuses to deliver the goods to the buyer, then also the transit will come to an end, means now he has not delivered the goods to the buyer, the goods are lying with the transporter. Where the goods are given to the carrier hired by the buyer. This is very, very interesting. This means the goods now, for example, A sold certain goods to B. So B said, I am sending my own transporter and he will come and take the goods. So once you have given to the transporter who has been hired by the buyer himself, that means the goods have been given to the buyer. Now they're not considered to be in transit. Where part delivery of the goods has been made to the buyer, transit will come to an end even if they're yet in transmission. So part delivery has already been made. Now the transit will come to an end for the remaining goods. So now you can exercise, I told you in case of part delivery, section 48, where the buyer has failed to make the payment, I can order for my goods to come back. But provided I cannot take the goods back if the delivery has already has been made to the buyer. Let's see the last point, where the goods are delivered to a ship chartered by the buyer. So buyer ने अपनी ship भिजवाई है कि इसमें मेरे goods load करके भेज दो. तो जब buyer का agent है, buyer का transporter है, buyer की ही ship है, तो transit में नहीं माना जाएगा. It will be presumed that the goods have been taken by the buyer. Unpaid seller can exercise his right to stoppage by taking the actual possession of goods or by giving the notice to the carrier. Either he will come and take the goods from the truck with himself, or he will give a notice, means he will call the transporter that please bring back my goods. Such notice can be given either to the person who is in the possession of the goods. The notice will be considered effectual, shall be given in such circumstances by reasonable diligence, and may communicate to his servant or agent in time to prevent a delivery. That means the seller immediately has to take an action that, look, please hold my goods, don't give it to the buyer. Why? Because once they're given to the buyer, I cannot exercise my right to stoppage and transit. Then I will have to bear the losses. फिर मैं और rights तो exercise कर सकती हूँ, but right to stoppage and transit नहीं कर पाऊँ. And when the notice is given by the seller to the courier, he shall re-deliver the goods according to the direction of the seller. And who is going to bear all these expenditures? Seller will bear, because he has stopped the goods in between. Na? So seller will, for example, I have loaded the goods in Chandigarh and they're going to Delhi. And now before they reached Panipat, in between only I called up the transporter, please bring the goods back. So now obviously expenditures have to be borne. He was to deliver it to Delhi, but from Panipat again, he's bringing back the goods to Chandigarh. So all this expenditure which he has to incur from bringing the goods from Panipat to Chandigarh, I as a seller will have to bear these expenditures. So what is the difference? This is your homework. You have to read it. Right to lien means retaining the possession. Stoppage means regaining the possession. Again, you have to tell him that here the buyer is not insolvent. Right to lien can be exercised even when the buyer is not insolvent. In case of stoppage and transit, it is a must condition that the buyer should have become insolvent. And this comes to an end as soon as the goods have gone out of the possession. Stoppage and transit comes to an end when the goods have been delivered to the buyer. So it is very, very simple points. Read it, learn it. In fact, after reading the differences, you will become much more clear about right to lien and right to stoppage and transit. Now let's move to section 53, effects of subsale. Now this is very, very important. I hope till here all the points are absolutely clear, because I want to finish off this chapter also. Acknowledge means to confirm, to tell the third person that I'm holding the goods on your behalf. Ms. Renuka, if the carrier has stolen, then a case will be filed against him also. Ms. Preeti, I hope doubts are cleared now. If you want to ask something specifically, you can ask. Let me first finish off this chapter and then we will take up the doubts at 12:55. Subsale or pledge by buyer. Now, section 53 is very interesting. Child, if I am the seller and I sold the goods to buyer, Mr. Anuj Kumar. So I sold the goods to Anuj Kumar and Anuj Kumar further sold the goods to Miss Preeti. That means subsale has taken place. A buyer has sold the goods to another buyer. Now, what will happen in this case? It says second buyer will not get a better position than the first buyer if the payment has still not been made. If my payment is pending, I can still exercise my right to lien or stoppage in transit depending upon whether I have the goods or not. Let's take the example. A sold the goods to B of Mumbai and the goods were handed over to the railways for transmission. Now, what is happening? A has loaded the goods in Mumbai and they are given to the railway authorities. Now, this is the case of railway receipt. Remember when I told you that even before the goods are received by the buyer, by endorsing the document of title to goods, he can sell it to another person. So here he sold these goods to C. Before he received the goods, he has given this railway receipt to Mr. C. Now C can go and collect the goods from the railway authorities. But B became insolvent. A can still exercise his right of stoppage in transit because seller has not allowed B to do this subsale. Has not given his assent means, remember in the case of estoppel where I told you that A said, yes, B, you can sell the goods to C. If A is allowing, assent means he is giving the permission, he is allowing B to sell the goods to C, then he cannot exercise the right to lien. But where no assent has been given, no permission has been given by B to sell the goods to C, then A can exercise his right to stoppage in transit. He can order the transporter to bring back his goods because B has become insolvent. He will not be making my payment. So I quickly called the railway authorities and told them not to give the goods to B or C either. Please give my goods back. All right. So let us see where are the exceptions. So I hope example number 6 you have understood why we have taken the goods back, because he has not given the consent. So यहाँ पे आप छोटा सा लिख लो अपने words में example 6, buyer cannot sell the goods to sub buyer where seller has not given his assent means consent. Consent means हामी भरना. Here seller can exercise his right to stoppage in transit. So where I have not allowed you to sell the goods further and you sold my goods further without making my payment, I can exercise my right to stoppage in transit if buyer has become insolvent. Clear हो गया? But there are certain exceptions where the unpaid sellers and lien and stoppage in transit comes to an end. Defeated means, that means now, what are the cases where I can, this case is clear. Example 6, what is section 53 telling you? That if seller has not given the assent, you cannot sell my goods further. I can still take it back. But what are the exceptions where the seller has assented to the sale, mortgage, or other disposition? Mortgage is not a good word to be used in sale of goods. It should have been the word pledge. So pledge means where you're giving my goods as a security and taking loan from the other party. And if the seller has given you the permission for this thing, then my right to lien will come to an end. Or where the document of title has been transferred and the buyer transfers it who buys in good faith. Then in such a case, again, if it is happening by sale, my right to lien and stoppage in transit will come to an end. But if it is the case of pledge, then I will get all the rights of pledging. Means now I can go and take my goods back once the pledge, once the loan thing has been repaid, I will be acting as a bailee for my goods. Let's read it one by one. So what are the exceptions? Number 1, section 53 says that you cannot do a subsale. I have to give you the permission. So exception says where I have given you the permission, where seller has given the permission for the sale mortgage, then I cannot exercise my right to lien. It is defeated means then it comes to an end. I cannot exercise it. A entered into contract to sell cartons in possession of a wharfinger to B and agreed that the B price will be paid to A from the sale proceeds. Now, this is a very, very interesting example. Number 7, I want all the eyes and ears here, please. Example number 7 is very, very interesting, children. A ने क्या कहा? A told B that I'm going to sell you the goods. And B told him that, look, I will make you the payment. जो price pay होना है, I will make you the payment only after selling the goods to C. And whatever I will recover from the sale proceeds from C, I will give you the price. So now arrangement of sale has been made in such a case that A is giving the permission to Mr. B to make this subsale. But B sold the goods to C and C paid B, but B failed to make the payment to A. So A quickly ordered the wharfinger not to give the delivery of goods to C. Seller has assented to the resale, therefore his right to lien has defeated. Now A is in a major problem. In example number 6, A could take his goods back because he has not given the permission. But in example number 7, children, you tell me, can A take the goods back from C? Why he cannot take the goods back from C? Why his lien has come to an end? Tell me quickly. Why his right to lien has come to an end? Mr. Hemant HK, once you have taken the goods back, recovering of money, you can file other kind of cases also against the buyer. Okay. I'm not getting your answers, student. Are you giving me the answers? Why he cannot take the goods back from C? Because the goods have already been delivered. Okay, that's nice. Because Surya Patra, very good. Because he has given the permission. Miss Anshuka, correct. Renuka, correct. Very nice, students. Because he himself has given the permission for this kind of sale. So that is how you have to remember this. And where the document of title has been given to the buyer, then also if you are making a sale, your right to lien will come to an end. But in case of a pledge, you can still exercise the right subject to the rights of the pledgee. So pledger is the person who is pledging the goods and the other person is the pledgee. So whatever rights are available with the pledgee, that can still be exercised. So pledgee may be required by unpaid seller to use the goods available to him to satisfy his claims. That means he can ask the person that please pay off your loan and give my goods back to me if you have failed to make me the payment. Is that clear? Now let's quickly come up to the right of resale. I'm going to open my presentation so that you know where we have ended. So seller's right to lien, we have come to an end. Stoppage on transit we have done. These are the points where the transit is said to be, goods are said to be in transit. This is the case of subsale or pledge by the buyer. Subsale or pledge is the contract only if the buyer has given, only if the he has given his consent, then you can not exercise your right to lien. So here seller has given the assent for the resale of the goods. Therefore, his right to lien has come to an end. But unless you have not given or you're using document of title to goods, then you cannot exercise your right to lien. So now the last right against the goods is right of resale. So what is the meaning of goods of perishable nature? So there are two types of rights of resale. One is when the goods are of perishable nature and when the goods are not of perishable nature in any other case of types of goods. So when the goods are of perishable nature, suppose A has agreed to sell B 500 kgs of apples. 500 kgs of apples. Just imagine itne zyada apples बेच रहा है. Apples is a perishable commodity. B failed to pay in the price. A became unpaid seller. So what are you going to do? Will you retain the possession of these apples? It is a perishable commodity. Law says it is better you resell these goods. You sell it to another buyer because these apples will get rotten. They will get spoiled. There is no use of retaining the possession or regaining the possession. It is better to resell them in the market. Here, A is not required to give notice to the buyer. He can simply find another seller in the market. Mr. D, he found a seller and he sold all these apples to another seller. Without even giving any notice to the buyer, he can do that, where the goods are of perishable nature. So point number one in right of resale, number one, if the goods are of perishable nature. Number two, seller can sell the goods if the buyer has not made the payment. Number three, he is not even required to give the notice to the buyer for making such resale. Clear ho gaya? All the eyes and ears I want on the presentation. I'm not looking into the doubts. I will look at the doubts at the end. In other cases means if the goods are not perishable, any other type of goods. Suppose I had to sell furniture to buyer and buyer refuses to make me the payment. So now I will send a notice to the buyer that, look, I am giving you reasonable time of 10 days. You come and pick up your furniture and you make my payment. And buyers still refuse to come. Then suppose this furniture, 10 days have passed, reasonable time, he still failed to make the payment. And now this furniture table that I've made for the buyer, it was for 5,000 rupees. So now I don't want to have a loss of 5,000 rupees. I quickly found another buyer, C. But C said, I will only pay you 4,800 rupees. Now this table is lying like this. I have made it specifically for the buyer B. He has refused to buy the goods. He has refused to make me the payments. So rather than wasting it for 5,000, I agreed to sell it 4,800 rupees to Mr. C. So children, have I suffered any loss? The contract price was 5,000. I am reselling it for 4,800. I have suffered a loss of rupees 200. I can recover this loss from the buyer B. Because I gave him a notice, I gave him a time period of 10 days. He has refused to make me the payment. So law has given me the permission to recover this loss from Mr. B. And if I have sold this for 5,800 to new buyer, then I don't need to give any profits to B. I have already suffered so much because of Mr. B. So I will keep the profits to myself if I sell it for higher price. Simple. So in case of resale, there are three different points that you have to remember as a flow chart. Resale. Number one, perishable goods, no notice, and sell to new buyer. Baat khatam. Sell it to the new buyer. Other goods, give notice to buyer. If loss, recover. If profit, retain. Retain means to keep it with yourself. If you have suffered loss, then you can recover it from the buyer. So this is the summary of your resale of goods. So we have done resale also. We have done sale to sub-buyer also. Let us quickly see what are the rights. See, in 2019, he has given you straight away question. What are the rights? Generally, student, question number 4, 5, and the last question is from sale of goods. So question 4, second part, 6 marks question came. What are the rights of the unpaid seller against the goods as per the sale of goods? So what are the rights of the unpaid seller against the goods? In this case, you will write all those rights: right to resale, right to lien, right to stoppage in transit, and right to resale. As it is, whatever we have discussed till now in the class, you have to write down in points. That is the correct answer for this one. And what are the rights of the seller against the buyer? There were certain rights against the buyer also. We have done all the rights against the goods. What are the rights against the buyer? So now listen very carefully. If I have given you my goods and I have not given you my goods, the goods are lying with me and you fail to make my payment, you have learned that you will retain the possession of the goods. Or if they are with the truck driver, you will call him and you will ask for the goods back. Or you can resell the goods. But if I have given the goods to you, all those your query will now get answered. Those who were saying, ma'am, अगर हमारे पास goods है ही नहीं, अगर buyer ने goods ले लिया, तो अब हम क्या करें? हमारी payment नहीं आ रही, तो हम क्या करें? तो हम ये वाले rights use करें. Suit for price means we'll file a case order in the court, we'll file a case against the buyer, and we will ask him to pay our price, even if the property has not been passed, even if it was an agreement to sell. Then also I can file a case because I made a contract with you, I made an agreement with you that you will come and buy my goods. Now you have refused to pay me the price, so I will go to the court and file a case against you for the price money. Or I will file a suit for damages. What is the meaning of damages? There can be ordinary damages or special damages, whatever is the case. If I have suffered any damages because of this breach of contract. Bacha, what is this all topic of remedies of unpaid seller against buyer means? Breach of contract done by, where the contract has been breached by whom? Buyer or seller? Breach of contract. यहाँ पे लिख लेना है. Breach of contract by buyer. When breach of contract is done by the buyer, seller can file a suit for the price. He can file a suit for damages. How will he file a suit for damages? I wanted to sell you the goods for 1,000. Now I have found a new buyer who is paying me 900 rupees. I have suffered 100 rupees loss because of you. So I will recover these damages from you. Or I will file a case for interest money. In certain cases, we have made a contract that you will buy the goods for rupees 10,000. And if you do not pay me the contract price, I will charge you the interest over and above amount. So whatever interest has been agreed from the date of fail of payment till the due date of making payment, interest will also be recovered by filing a case against the buyer. And the fourth right available to the seller is repudiation of the contract before due date. Repudiation means to put an end to the contract. So there are two types of breach of contract. One is actual breach of contract. One is anticipated breach of contract. Now what happened is that I had to deliver him the goods on 10th of February. So on 7th February, I came to know that the buyer is not going to pay me the price. But then I kept the contract valid and open till the due date of 10th of February, that I will kept it open and now I will wait whether he makes me the payment or not. But where I have come to know on 7th February, it is an anticipatory breach of contract. I will end the contract on that very date and I will file a case against the buyer. So all these points which you have covered under breach of contract, actual breach, anticipatory breach, you have to refer to all these points under Indian Contract Act. It is the same points as the rights have been given to the seller to file a case against the buyer in case he fails to make his payment. So if you fail to make my payment, first I will exercise the rights against the goods, that is my right to lien, stoppage and transit and resale. If all those rights have ended, the goods are already with you, then I will exercise my right to file a case for price, interest, damages, or I will put an end to the contract before the due date and take an action against it. And the last, rights of the buyer against the goods. In the same way, where the seller has breached the contract, rights of the buyer के आगे लिख लेना. Cases where the seller has breached the contract. In the beginning of the class only, you told me, ma'am, if he has refused to deliver the goods, then that means he has breached the contract. So buyer will file a case for the damages for non-delivery. You have not delivered me the goods. I will file a case against you that because of you, I could not make the sale further to my wholesaler and retailers. So I have suffered the damages. I can recover those damages. Or for the specific performance, I have asked for a particular antique painting or Mughal painting, which is very difficult to find from other person. I have made a contract with you. Now, if you fail to deliver me, I can take an order from the court for the specific performance of this type of contract. Or for the breach of warranty, you have breached your warranty. I can file a case against you for claiming damages. I can also repudiate or put an end to the contract before due date. And similarly, the buyer can also file a case for the interest money if he has failed to deliver him the goods on time. So you can refer to all these cases where the remedies have been given for the breach of contract of the buyer. When the contract is breached by buyer, seller has 5 rights against him. Where the breach of contract is done by seller, buyer has these kind of 5 rights against him. And the last topic of auction sale, I will take up in the next class, because if I just try to wind up in 5 minutes, then you will not understand. So in the day after tomorrow's class, when we start off with the Indian partnership, we will take up the topic of auction sale also. Now is the time for your queries. If you want to ask something, you can ask it. because as promised, I also want to do one examination question paper also with all of you. So you can ask your queries, those who wanted to ask. Now is the time. So 1 June 2023 question paper, somebody has raised it in query also that you wanted to understand that particular question paper. That is what we're going to take it up right now. So I'm going to open up the question in front of you, but I don't want to cheat and answer me. You have to answer me honestly. Okay. But before that, if you have any doubts, let us read your doubts also. Yes, very good answers, ordinary and specific damages. So you remember all this, suit for price, excellent. Who is a pledgee? So pledger is a person, very good, Dr. Mr. K. Manish Darshan. Pledgee is the person with whom the goods have been pledged. So one is pledger, one is pledgee. One is bailer, one is bailee. So as a bailee, you were supposed to take care of the goods. Here as a pledgee, you're supposed to take care of the goods because the goods belong to somebody else. So if I am the buyer and I have pledged your goods with some another person, so the rights available to another person are only of pledgee. He does not become the owner of those goods because he has taken a loan. The buyer has taken a loan. Once the loan is repaid, he will get the goods back. Thank you so much. Mr. Anush Kumar has written, we have learned also unpaid seller along with this classes. So wonderful. Mr. Varun, we'll be starting with partnership after doing auction sale from this chapter in the next class. Beautiful answers you all have sent in the previous question that I've asked. Very good. Divya, Nancy, Anushka, Navid, Ayush, Khushi, Priyanka, S. Sudhakar, Sanya. Very good. All right. So I can't see any doubts as of now because we have tried clearing all the doubts in between the chapter only. So here my question in front of you is, Mr. A contracted to sell his Swift car to B. Both missed to discuss the price of the Swift car. Later, Mr. A refused to sell his Swift car to B on the ground that agreement was void because of uncertainty about the price. Remember section 9 and 10 of Indian of Sale of Goods Act, where we said that the price of goods have to be fixed. So there are four things: either the price is fixed in the contract, or manner of fixing, or dealings between the parties, and if nothing has been fixed, reasonable price has to be paid. So here they are saying the agreement will become void because the price has not been fixed. So what do you think? What rights can be exercised under this type of contract? Does B has any right against A under the sale of goods? Please give me the answer for question 1C. What would be your answer? Yes, Mr. Jaiswal. Mayur Kumar, you can write an exam in your own words. Specific performance is specifically asking you that there is a contract which has I've made with you to paint a picture for me, and you're a classic painter. You can only do that, and I trusted you for making that painting. So now, if you fail to do that, I can take an order from the court for your specific performance of that contract. Yes, Mr. Varun, that's correct. Anushka, section 9. Very good, Anushka. Section 9, I already gave you the reference. You have to tell me the answer. What will be the answer for this question? This is your test time. You have to give me the answer, student. B has the right to get the car for reasonable price. Very good, Mr. S. Sudhakar. So now 4 marks question. How are you going to? Very good. All those who have given the answers, reasonable price is the correct answer. This is how you have to attempt the question. As per section 2, price is the consideration. So, ma'am, do we have to remember section 2, subsection 10? No, not compulsory, but you can simply write down as per the provisions of Sale of Goods Act. First, he is defining what is the price. Price is the consideration which you have to pay for sale of goods, and it is a basic requirement. So, obviously, contract cannot be valid if there is no agreement about the price, but it has to be agreed. And the price, manner of fixing the price is given under section 9. It will decide how the price has to be fixed. Even if both the parties have missed they have missed to discuss the price, it will not make the contract void. It will be a valid contract. They can pay a reasonable price. So this is your concern provision that you have to write, first two paragraphs. This is your facts of the case, and this is your conclusion. Mr. A and B entered into a contract. They have decided they did not fix the price. A has refused to sell the car. B can legally demand. Till here is the facts of the case. And this line, both the parties missed to discuss the price. Still, it is a valid contract. They have to pay a reasonable price. Therefore, now at the end, you have to write B can legally demand the car and can recover the reasonable price. That is how beautifully you have to attempt the answers. The provisions should be very clear. The facts should be very clear. And then this should be your conclusion along with this last line that now he can legally demand the car from Mr. A. हो गया ना लर्न? देखो आप कैसे कह रहे थे कि हमें आता नहीं है, लर्न नहीं हो रहा. अब आपने आंसर दिया. ऑल ऑफ यू हैव गिवन द करेक्ट आंसर. लेट्स क्विकली सी अनदर आल्सो फ्रॉम दिस सेल ऑफ गुड्स का एक और क्वेश्चन आया हुआ है जून 2023 में. Let us read that question also. For Indian partnership, Indian contract, unless and until you have not revised, please don't check the questions. Now, straight away question has come, children. You were asking me, ma'am, straight question, 6 mark का straight question. What are the rights of the buyer against the seller in case of breach of contract? हमने अभी पढ़ा है question number 4A. जल्दी से मुझे इसके answers दे दो. Thank you, Mr. Surya Patra. Thank you, Anushka, if you have enjoyed the class. Thank you so much. What is the answer for question number 4? The rights of the buyer against the seller. So all those points that we have discussed under the breach of contract, buyer will have all those rights for filing a case for non-delivery of the goods, breach of warranty, reputation, suit for interest. As it is from the study material, they have taken these points. You can write it in your own words as well. And the last question is from auction sale. That is when we do auction sale topic in the next class. After that, we will be taking up this topic from the examination question paper. So I hope you all have understood. Thank you so much, everyone, for lovely comments. And I'm glad you have enjoyed the class. Please, your homework is revise all the 4 chapters. Apart from auction sale, a small topic which we'll take up in the next class. Apart from them, whole sale of goods is complete from my side. Read all the MCQs given in the study material and also try writing practice of the descriptive questions. So I'm going to ask you, I'm going to take your test of descriptive questions next time in the next class. Any question will be given to you. You have to tell me the answers for that. But that is possible only if you have made written answers for those questions which are given in the study material. Thank you, Priyanka. Thank you all of those who have written all the concept clear. I'm glad to know that. Please revise and see you in the next class. Goodbye, all of you. See you on Thursday. Thank you.